to the question of federal judges, we have a Religious Land Use and Institutionalized Persons Act that protects religious land use. And of course, it's a federal act of Congress, unanimous in 2000. It's always heard before federal judges. So the Obama appointee says, I'm not even going to hear this case. And you have to come to the legislature to say, hey, we in 1979 had a religious exempt child day center for religious institutions. If a religious institution qualifies for all of that code compliance, safety, et cetera, for the children that it's already caring for in daycare, before and after, and preschool, why would we not then also be exempt from adversarial zoning in the state that forbids these institutions from having private religious schools? Do you have any thoughts on that?
That sounds more like a state decision rather than the feds. I mean, what you could do, I mean, very little in the way of property law was given to the federal government. You only have the fact that you're supposed to be secure in your persons and papers and effects, and if land is taken for public use, you receive just compensation for it. But really, property law was the purview of the states. They did not give it up, you know, to the federal government. So that's got to be handled that way. If there's a question of equal treatment, you might come in. But let me tell you what I did one time. When the IRS was going after private Christian schools, denying them their tax status unless the school proved that they weren't racially discriminatory. I said, this is the accusation. This is not the proof that they have to say you're, you know, discriminated against, you know, people of color, but you've got to prove you're innocent first. That's not the way we work. So what I did, I talked to the senior LA for Tom Eagleton, who had all these Missouri Synod schools in Missouri Synod Lutheran schools, and all the Christian schools, mostly Baptist. And I said, I'm going to devise an amendment, but I need you, Dornan's going to do it on the House side, I need you to do it on the Senate side, on the Treasury bill. And what we did, I got the IRS letter ruling, the number ruling that they were using to go after these schools. And I said, I devised the amendment, I said, none of the money authorized to be appropriated under this act shall be used to enforce IRS ruling number 123456. We added it in the House, added it in the Senate. The IRS is dead in the water. They couldn't use a dime to enforce that. So we got this monkey off the back of the private schools, so it reverted back to the prior ruling where the IRS had to prove you were discriminating, not the new one where you had to prove you weren't discriminating. So I did that, and it passed, it became law.